Hello. Hello.
Hello.
Is that you?
Hi, Monica this side.
Oh, hi, Monica. This is Anu here.
Hi, Anu.
I'm just going to make you the co-host. Okay.
Sure.
Nikin will be here in a bit.
Yeah,
I am just we are broadcasting this live on YouTube, so I'm just going to set this up. Okay, and come
sure.
back.
Yeah. Hello, everyone.
Okay. Hey, Monica.
Hey, how are you?
Doing great. Can you see and hear me okay?
Yes.
Oh, wonderful. Yeah, just give me one moment. We are getting set up.
Sure. Yeah.
Can you see and hear me okay, Monica?
Yes.
Hey Vijay, how are you doing? If you're saying anything, you're muted, but I've asked you to unmute. Awesome. Let's give a few more minutes. We'll also send a blast to all the registered attendees.
Sure.
Monica, and just want to be respectful of your time, so we can get started whenever you're ready. What I'll do is we can do a full session, so I can bring you up. You can
Sure.
share the screen, do the presentation, and whoever joins, they can join, right? So we'll keep them engaged throughout.
Yeah, definitely. I'm ready, but yes, of course, we can wait for just 2 minutes so that if anyone is joining, they can.
Okay. Hey, Priyadarshini, how you doing?
Hi, I'm good. How are you?
Doing great. If I remember
Awesome.
correctly, you're in Pittsburgh, right?
Oh yeah, I'm in Pennsylvania. I'm kind of in
Pennsylvania.
Central PA, Philly.
Is it what's the weather like right now?
Oh my goodness, it went until -10. So right now we are juggling between -10 to +10. So
That's a
It's
huge
so cool.
variation. Yeah. I'm actually traveling and between the Bay
Oh,
Area
okay.
and right now even I'm in close to Philly.
Oh, great. Okay.
So kind
Awesome.
of landed a few days ago and I was like, oh, I wasn't prepared for this weather.
Awesome. Are you here for business or just a laser trip?
My wife's family is based here.
Oh, based in Philly.
Yeah. Well, South
Awesome.
Jersey.
Okay. Oh, great. Okay. Okay.
Cool. Appreciate you making the time and we can get started. Ready from your side, Monica?
Yes.
Cool. So thank you everyone for taking the time to join us today. My name is Nick and I'm one of the curators at Open Atlas. Super excited to be having our guest speaker, Monika from Asanwell. They're doing some very important work in terms of helping families prepare themselves, having a plan on financial continuity. Monica will talk more about why a will is necessary, what the team is doing in order to equip, especially expats such as ourselves, about the situation. And in case you have any questions, please feel free to use the chat. And at the end of the presentation, we'll ask, we'll answer the questions in the order that we receive them, or we'll just unmute you and ask your questions directly. So without further ado, really appreciate you taking the time, Monica, and the virtual stage is yours.
Thank you. Thank you so much. Hello, everyone. So, thank you for joining us from different parts of the world today. And I want to start with something most of the NRIs believe. You work hard abroad, send money back home, invest in properties, mutual funds, bank FDs, maybe even build a house for your parents in India. And naturally, you feel that my family is secure. My assets are, everything is in place. So, what could go wrong? But here's the reality: when something happens to NRI, banks freeze that accounts in India, nominees don't become owners, multiple legal documents are demanded from the legal heirs just to claim which is already belong to them. And Indian legal procedures can take like months or even years. So, in this webinar today, we will discuss the importance of will writing, why it is important, understanding the different legal hierarchy, what by default the Indian succession laws work, nominee versus legal heir, and what are the key elements when you would like to create a will. And then at the end, we will discuss Q&A round. So whatever questions you have, you can just keep it in the chat box, and then we'll keep the session quite engaging. So first of all, I'll start with this core problem in India. There is no national register in India where your family can track that what assets, what investments you have done. There could be multiple assets one person can have. It could be PF, gratuity, FDs, mutual funds, DMAT, shares, LIC, flats, ancestral properties, lands in India, any other foreign assets. So there could be a lot of assets, but how your family will get to know what all exist and where they will start and how they will claim all your assets. So it's very difficult. There is no proper guidance and very little transparency. So this is the biggest problem we are trying to solve today. Now, why we are talking about this? There's already like 5 lakh crores of assets are lying in unclaimed assets. That's where we discuss that one person can have these multiple types of assets, and when family have no clue that my husband, my father, my parents have invested in that much assets. So that's why lot of assets, currently 5 lakh crores of assets are lying unclaimed. Family had no clue. And then lot of people are dying annually across the world. And inheritance court cases are pending already in Indian High Court, Supreme Court, Session Courts. So 12 million plus court cases are already pending. This is the structure of raising unclaimed assets, and that's why families are suffering. So various bank accounts, PPF accounts, insurance policies, mutual funds, there is a lot of money is lying unclaimed. There is no nomination on record, and families had no idea that this wealth exists. These assets are in place. And it takes family members sometimes months and years to just figure it out what all the assets are lying in their family members' accounts. So now let's discuss why writing a will is important in India. So first of all, you create a list of your assets because there is no by default national asset registered in India. So you can just create a list of your assets, and then you can mention your wishes, how you want to distribute your hard earned money, how you want it to transfer to your next generation. And it prevents family disputes because if there is no documentation, your family, your children, your siblings, your extended family members can fight over the assets. This is what happening in real time. So it protects from the disputes, and it saves time and costing for your family members, because if there is no documentation, your family will have to run from pillar to post just to acquire, which you are trying to safeguard for them only. And there will be loss of assets because they won't be able to trigger and track every single asset. Now we'll discuss who needs a will. So it's a myth that only the rich or wealthy people needs a will, but it's not like that. Everyone needs a will document. Either they are married, they are first time home buyers, if they have parents, if they are single parents, if they are separated or in mid of divorce procedure, if they are retired. In every stage of life, there is an importance of proper documentation. If somebody has any questions, you understood the topic, what we are discussing today, just let me know if I'm running too fast or anything. Okay, so now let's discuss what happens after death in India. So if someone passes away without any proper documentation, then their bank accounts legally freeze. The banks will not release the money in the bank accounts until unless they will receive the proper set of documents. These documents can be the death certificate, the KYC of the legal heirs, even the relationship proof. Even if I am daughter of my father, the banks would ask me to prove that via a succession certificate or a legal heir certificate. And that's really pain in India. It takes like months to years to just acquire these certificates. And third issue is succession law applies automatically. So it will be based on your religion. If you are following Hindu, then Hindu Succession Act is applicable in India. If you are Muslim, then Muslim personal laws will be applicable in India. And sometimes it's based on your marriage as well. If you are your marriage is registered under Special Marriage Act, then different laws will be applicable. If you are following Christian, then Christian personal laws will be applicable. So there is a fixed legal hierarchy how your assets is going to be distributed among your family members, and then it will increase the time and costing to just acquire your hard-earned money for your children. And again, that's the one point which we discussed. There will be always a risk of losing some of the assets because family members won't be able to track everything. Now I would just like to discuss about the legal hierarchy, how the legal hierarchy works. Vijay, you have raised your hand. You can unmute yourself and just speak.
Yeah, hi. So one question on this slide, the risk of losing assets. How long before an asset is unclaimed, will one lose the asset? And when you say losing an asset, is it government seizing the property? How does that work?
Correct. So, for example, there is a bank account and there was one FD and shares. So, like if within 2 years, 3 years, if nobody is coming to claim that in absence of the knowledge, for example, someone passed away in my family and I had no clue that he had invested FD for me. How should I go and claim that FD? So, if no one is coming to claim that amount, that asset, then there is a fund, there is a government fund in India, so that unclaimed amount will be transferred to that government fund, administrative fund.
I
So
see.
that's
And
where
how
we see.
long and how long is that period in between? Is it like a few years, or is there a
Yes,
like a
correct. So asset
guideline
wise,
for
there are different policies from the RBI. Yeah, for
it? Mhm.
example, FD, you can claim it within 2 years, and then there can be some penalties as well if you don't do, because there are always a lot of compliances post demise as well. You have to do some compliances, you have to do filings that yes, there is demise in the family, and you have to submit
Right.
the death certificate, you have to do that closing ITRs and all. But if you don't do that, then there could be some other
I see.
compliance
So we're
risks.
looking at a minimum of 2 years before which you'd have
Correct.
to start some
Correct. So
procedure.
different
Okay.
assets have a different policy, 2 years, 3 years, 6 months, like that. But yeah,
Okay.
minimum it
Thank you.
works like that only.
Thanks.
And you will see that if we talk about like shares, which are like, before this nomination made compulsory in India, then there was no nominee, and most of the shares were in physical format before the digitization and all. Indians used to invest in a form of physical shares, and then there was no nomination. So that's why these unclaimed assets bucket is just increasing day by day. Yes. Okay. So next, I would like to discuss about the legal hierarchy. So again, there are a lot of assumptions around it. So Mr. Vijay, I would like to hear from you here. For example, if a male member passed away without writing a will, he had his wife, children, parents, and siblings. So what are your thoughts? How this, his entire assets will be distributed among his family members? Would you like to share some
Um,
thoughts?
I'm not sure. I think you mentioned that it depends on the personal law, on
Correct.
based on their religion. So I guess that would apply. But I have a dumb question. How does the government know that someone has passed versus someone has just forgotten about their asset in a long time or never accessed it? Like when does that clock trigger? That counts to two
So
years or
see, for example, if someone passed away in the family, there could be something that yes, family knows. It could be their Aadhaar card, it could be their, PAN card, and any of the bank account. So first document which is needed, or the hospitals also issue, that is a death certificate. So then it is, whenever the death certificate is issued, it is automatically in the government's record that this person has
Oh, I
passed
see.
away.
So that triggers the
Yes,
clock. Let's say
correct.
I have an asset that I haven't touched in 10 years. I shouldn't be worrying about telling the government, hey, I'm alive, right? Like KYC,
Yes,
I keep getting these emails to update my KYC every 2 years or
correct,
1 year from
correct.
a
Yeah.
bank. I was just worried if we have some asset, like a piece of land, which you generally don't go and we tell the government, hey, it's still mine, right? So you're saying that the death certificate, when you apply, that triggers the clock.
Correct, correct. Yeah, because until the death certificate, the banks just follow to update the KYC. If someone is not coming, they give the deadline that yes, by till, for example, 10th of December, there is the
Mhm.
last date you can come and update your KYC. If someone is not coming, they just send the letter to their house. They try to email,
I
get
see.
a
I see.
possible conversation. But if something is not coming, they might keep it as okay. They will freeze that account.
Got it. And how does that work? I'm sorry for back-to-back questions. How does it work for lands? Bank accounts, I understand, but how about if you own a piece of land? How do you tell the government the KYC equivalent?
There are different revenue authorities and local authorities in India. Whenever we have to do the name transfer of the assets, there will be tax receipts or multiple things connected with that piece of land. But the
I see.
state regulations will be there. Again, there is no single universal rule here. The local rules will differ.
Got it. Thank you.
Yeah, so coming back on the main discussion here, if you can just share your thoughts for that scenario. If one male person passed away and having these family members, wife, two children, and siblings and parents. So, based on Hindu religion, what do you think that how the asset should be transferred among these family members? If the entire assets will go to the spouse, or if the entire assets will go to the children, or based on your like thoughts, anyone can
Wouldn't
just
wouldn't it be split amongst all of them equally?
okay. Any other
That
thoughts
would be
anyone
my
else?
guess.
You're close to it. Okay, all right, I'll move to the slide then. Yeah, so this is the simple example. I just try to keep it in an explanatory way. So if a Hindu married man with children dies without writing a will, then his assets will be equally distributed among the surviving members based on the class 1 legal hierarchy. So in the class 1 legal hierarchy, the spouse, the children, and his mother will be given an equal share. Here, the father gets nothing. So you see, if some son, any of the son passed away in accidents or any other reasons, then the father gets stuck. Nobody is there to, take care for the father. So we have seen these scenarios practically that's going on. And then there's court cases, the daughter-in-law is not taking care, the grandchildren, the children are not taking care, and then father is just left without anything.
And a clarification here, what's the definition of a child here? Is it a child of any age, or is the
Yes,
child
any
18
age
years or
and
young?
no, child of any age. Yes, and both son and daughter gets an equal share. Even after 2005, in India, married daughters are also getting an equal share in the father's property.
Okay. But
Yeah.
is surprisingly his mother also has a share.
Yes, correct. But father is not getting anything. So again, it's yeah, not an equal distribution. If these members like children, wife, and mother, all of them are not there, then only the assets will go to father. So father is part of a second class legal hierarchy. So there is a legal hierarchy, class 1, class 2, class 3, like that. So now in case of women, it's again surprising. And these laws are created in 1956, and now we are in this, and women's are also independent. They are acquiring a lot of self-acquired assets. They are working nicely. But if we talk about women scenario, so any women who has their self-acquired property and she passed away without writing a will, then her entire assets will be equally distributed among the children and husband. Her own parents, her own siblings, her birth family does not get anything. So again, these laws are not similar if we compare male and female. So if women needs to secure their parents, their siblings, if anyone in their birth family, because it's her self-acquired property. If she is getting married in 30s, 40s, whatever, it's her parents, they are standing with her, they are supporting her. And if something happens, she can't even give anything by default. But if she writes a will, then it can be transferred to as per her choice. And again, the scenario is strange. If husband is not there, then this women's property will go to a mother-in-law, even though it's not with her parents. So husband and husband's family will be, given priority, not her own parents. or her siblings. So that's where like 80% of
Wait,
our
this
women
is
customers are just being aware now. Sorry?
this, this is happening in 2025?
Yes, yes, this is happening.
Yeah, please go ahead, Pratish.
Yes, please.
Uh, yeah. So I just wanted to ask you, I mean, it's a basic doubt. So what if the kids are adopted? Like, how does then I mean, how does it work then?
Good question. So in India, the biological children and the adopted children gets an equal share when we talk about the inherited of assets.
Okay,
Yes. Adopted son will also acquire the equal share just like the biological son.
understood. Thank you.
Yeah, just keep coming with these questions, then only it will be a good interactive session. Otherwise, this topic is very, tough and then just hard to digest everything in one single session. Yeah, so these are few scenarios about women. So if women dies with no children, everything goes to husband. And if again women's parents get nothing, that's what we discussed. But yeah, if she's unmarried, then it goes equally to her mother and father. But her siblings don't get
What
anything.
if she is married and the husband passed away before her?
Then her assets will go to her mother-in-law. Her parents get nothing.
Okay.
Now, I would like to discuss a very important point around nominee versus legal heir. So, I believe you all are aware about this term nominee. And nowadays in India, like RBI, SEBI regulations are there, and nomination has become mandatory part when we open any bank account, we invest in any demat shares or any other financial assets. But again, this nominee is not your legal heir. He or she is just the custodian of your assets, a trustee of your assets. He cannot consume the entire assets. Legal heir is different. I'll give one example around it. Yeah, so here is the example. Let's take an scenario. Unmarried woman, there was a bank account and she nominated her father as nominee. Now she got married and this legal hierarchy shifts. Now the legal heirs are husband and husband's family. So even though father is the nominee, but father is not the legal heir. So father being nominee, he cannot claim the entire assets. The bank can release the funds based on the nomination, but it will be equally distributed among the legal heirs. So this father cannot claim this 300 rupees being nominee. It just he will be treated as a caretaker of this asset. And thus this 300 rupees will be equally distributed among women's legal heir based on the legal hierarchy. So it's not like that some a lot of our customers say that yes, my wife is the nominee on all my bank accounts and also everything will be passed on to her. Then we say them, advise them. It's not every time it will not happen like that. If you want your wife to be secured, then you need to mention this in the will document. Otherwise, it will be equally distributed among your children, your mother, and your wife. And will document always supersedes. If you mention your beneficiary in the will document, then this document will supersede your nomination. Any question around this?
Yes, I have got a question.
Yes, please.
So when it says that like the asset of a self-acquired woman will be distributed equally between children and husband, and it will be
Yeah.
half and half. What if there are two children? Will it be one third, or half of it goes amongst all the children and half of it goes to the husband?
So two children, husband, then these are total three members. So it will be equal distribution to all three.
Okay, so it will be one
If
third each.
yeah, three children, one like husband, then it will be distributed four portions. So
Okay.
children and husband got an equal share.
Okay. Thank you.
Yeah, so now we will discuss the types of wills in India. So, first of all, I'll just clarify what is a will. Will is a legal document wherein you mention your wishes, how your wealth will be distributed to your next generation, to your children. So, this document is created during your lifetime, but it come into force, it will be executed after demise. Okay, so these are the types of a will. Most common is last will and testament, wherein we put our wishes, how we want to distribute our wealth. It could be equal share to our family members. It could be individual assets. For example, I'm saying my house will go to my son, my jewelry will go to my daughter, my FD, my bank account will go to my wife, and so and so. Joint will. Joint will is a concept wherein the couples write a single document. When they acquire some assets jointly, they write a single document instead of writing two separate documents. So, again, there are a lot of pros and cons of writing a joint will. If someone has specific questions around it, we can discuss in detail on it. Then, mirror will. Mirror will is about for example, husband says that my entire assets will go to my wife, and wife also says that my entire assets will go to my husband. So it's a mirror wishes. So that's why it's known as mirror will. So it's most common in India for couples who are like above 55, 60 in the age group. So they just want to secure each other, and then they want to give. If both of them are not there, then it will be passed on to our children, like that. Then there is a new concept, like there is again, it's in media, living will. So living will is a medical directive. If you want to just give advance directives, how you want to be treated in case of any medical situations, emergencies, then you can just give some guidance, and then someone will take care for your wishes. And then notarized will and registered will. So these you can just pick last will, joint will, mirror will, and then it will be either notarized or registered in India. I'll discuss in detail in my next slides about notary will and registered will. Now these are the key elements to consider while drafting a will. First of all, identification of the testator. Testator is the term which is used to refer the will writer. For example, I am writing a will for my assets. I am the testator. Important party is executor. Now you must be thinking that this will document will come into force after demise. Who will execute my wishes? Who will inform my family that there is a will in place? So that's the role of an executor. You appoint a person, a trustworthy person from your family, your friends, your network. It could be anyone. Okay. You appoint them as an executor, and then they take care for your wishes. They distribute the assets based on the will document. Now, accurate asset listing. You just list down all of your assets so that no single assets goes into the government fund, that unclaimed fund. You just list down that I have FD shares, physical shares, digital gold, everything. So there is a single asset registered that way, so that your family knows everything. Then specific bequest, how you want to distribute your assets. My house to my son, my jewelry to my daughter, like that. And again, there is another important point, residuary clause, which means any of the missing assets, any of your futuristic investment that can also be named in your will. Then guardianship for minors. So if you have any children who is minor, you can appoint someone as a legal guardian for your children. So this is very important for the parents, new parents who are in their 40s and 50s, they have their minor kids. They can secure the kids for any unfortunate situations. Then proper witnessing. So this will document becomes valid once it is signed, wet ink signature, and two witness. So two persons signing it as a witness. Then only it becomes a legally valid document. Digitally signed will are not recognized in India. Then medical certificate. It just doctor certifies that yet you are in sound mind and fit and fine to write a will document because it's a legal and crucial document in your life. Any questions so far?
What if the executor dies before the execution of the will?
So here we give you options to appoint up to 3-4 executor. So if primary one executor is not there, the contingent executors can take role. If no one is there, unfortunately, then after the will comes into execution, the court can appoint an administrator.
Okay, thank you.
Um, Monica, I have one doubt.
Yes.
So, if I write a will right now, and how long will it be valid, and how often should I be changing the will?
Yes. So it will remain valid forever. There is no like deadline and all. It will come into force only after demise. Okay. And you can change or update your will n number of times during your lifetime. But even if you miss to change it, so first of all, we advise updating the will on any of the life changing events. For example, there is new birth in the family, there is marriage in
Mm.
the family, or new assets acquisition. You purchased a new flat, new house. In these major, life change events, we can update the will. But even if it is missed, then the residuary clause will take care for your missing assets. You can
Okay.
name someone that my futuristic assets will be transferred to my wife as a residuary beneficiary. So there is no need to like update it every year.
Sure. Thank you so much.
So now I'll just quickly discuss how we can help you create a valid will. So first of all, we do a quick consultation to understand your family structure. And based on that, we recommend what type of a will you should go ahead. And then we need to create a list of your assets. You share a few details, not like the detailed information, no property documents are needed, just the listing of your assets. And then we draft your will within 48 hours and send you via email, and then we handle notarization or registration end to end in your city in India. And if someone is abroad, not possible to visit India in coming time, then we can handle the apostille in the home country. So you simply need to sign the will, and your witness also needs to sign. At this point, it becomes a legally valid document. So these are the some most frequently asked questions when it comes to estate planning. Yeah, these I can discuss in the last 15 minutes for Q&A session. Now, notarization versus registration. So, in India, once you sign the will and witness also sign, at this point it becomes a legally valid document. Then this notary and registration, these are the added layer of security to your will document. Since it's a crucial document, your assets are connected with this, and a lot of family disputes come because money is everything ultimately. And then, so let's understand where this notary will be done. Once your will draft is ready, then this notary will be done at the notary public, and registration is done at the sub registrar office in India. And processes the registration is more credible because it will be done at the government department. They will capture your biometrics, your photographs, your signing, everything is recorded in the government's record. And your family can also track the will if they lost the document, if they missed somewhere, then they can just track another copy from the government records. So now there could be confusion on why I should opt a notarized will and why I should go with the registered will. So this is like some basic criteria. If the family structure is simple, just like one son and wife, just nuclear family, they can go with the notarized will. And just one or two properties, and all childrens are aligned. There is no, dispute scenarios in the families, and everything is just a smooth structure. Then they can just go with the notarized will. But a registered will is recommended when you have more than one children, you have multiple immovable properties in India. In like one property is in Hyderabad, another is in Bangalore, another is in Mumbai. If you have multiple city properties, and then yeah, assets in different cities and different financial assets, you have stepchildren, blended families, or any past disputes in the family. And if you have NRI children or you yourself is NRI, then we highly recommend your will should be registered to avoid futuristic paperwork and disputes in the family. Yeah, now I'm open to do the Q&A, whatever questions you have. Let's discuss this one on one. Maybe I'll just check chat box. Yeah, I don't see any questions in the chat.
Monica, how
Yeah.
does I had a quick question. How does this differ if someone is of a Muslim faith, a Christian faith? I mean, just from a high level. And you also mentioned if they are married in a certain way, right? So could you please expand on those?
Correct. So as we discussed the Hindus legal hierarchy, in Muslims there is a fixed share. For example, the wife will get only 1/8 share and the son will get always the double share from the daughters. So that's where the legal hierarchy is different. The shares are different. In Hindus, it's an equal share. In Muslims, it's an fixed share to the members. Wife, son, daughter, there is a fixed portion. They will get 1/8 share, 1/4 share, like that. Similarly, with the Christians also, there is a fixed legal hierarchy.
And you also mentioned that the marriage had to be registered in a certain way. I might have misheard that. Or,
Yes. So yeah,
yeah, please.
one thing which you follow any religion, it will be based on that. If your marriage is registered under Special Marriage Act, wherein, for example, one is Hindu, another spouse is Muslim or Jain or any other religion, then it will be registered under the Special Marriage Act in India. Then, based on that legal hierarchy, Indian Succession Act will be applicable.
Okay. It's helpful to know. And is that a different set of rules than what we have discussed?
Yes, yes, it will be different setup of rules.
And sorry, I was just like wondering. So the role of a nominee is equivalent to an executor for that particular account in the case.
Yes, you got it right. So
Mm.
nominee will just submit that I am the nominee, that form, and then the bank will ask that if there is any legal heir certificate or succession certificate, then only they will release the fund. Then again, that getting that legal heir or succession certificate is time taking. It will cost you like lakhs of rupees. Minimum, it's like 1 lakh plus is the fee structure, and then it will take like 4 months to 6 months minimum to just acquire that legal heir certificate, and then only the banks will release the fund.
And to get the legal heirship certificate, like whoever we are putting in that legal heir certificate, they'll have to agree as well.
Yes, yes. So, for example, there are multiple legal heirs. They all need to sign on the papers, and one of the legal heir needs to appear in the court for the hearing. And there will be some NOCs and all affidavits will be signed by all of the legal heirs. For example, if there are four children, all four needs to sign the papers, the documents. If any one is creating the dispute, then the court will handle it in a different way. That there is a dispute in the family.
Yeah, makes sense.
But if there is a will, the children can just bypass and avoid that, getting legal heir certificate requirement, and they can just showcase this will document and then just claim the assets. So that's where it becomes an important document.
Will the will be applicable even if the asset is in a foreign country?
Yes. So here what happens? The assets you have in India, there will be a will, Indian will. If you have assets in US, UK, there will be separate document. So this is a country specific document.
Okay. So for the
Uh,
assets in a different country, we have to have a will here.
correct. Different will.
Okay,
So we do help with the foreign will as well.
cool. Thank you.
Because these laws are country specific. Indian Succession Act governs only those assets which are located in India. Yeah, someone just asked what types of assets we can include in will. So all of the assets, either immovable or movable. Immovable assets are your land, house, flats, and movable assets are all your financial assets, FDs, bank accounts, mutual funds, jewelry. So everything can be mentioned in a single country document. Your shares, your trademarks, your IPRs, your social media accounts, your digital assets, digital gold, everything.
So our social media handles come under the category of assets as well.
Yes, absolutely.
Any other questions?
Uh, I have one.
Yes, please.
This is a real life situation I wanted a clarity on.
Okay.
Uh, a mother, a portion, like a part of the land is on the mother's name, and the mother has said wordly that she will be passing the land to the son, but there is no will. But the son has already constructed constructed a building covering that promised land with a
Okay.
legal signature from his sisters, saying that we are aware that the mother is going to give this property of the land to my brother after the demise.
Yeah.
Should it be moved legally with a will, or this legal signature alone can be taken into account after the demise of the mother?
We have to see the document wherein the legal signature is done. This document is known as the relinquishment deed, wherein we release our rights. For example, I'm the sister and I'm saying that there is a relinquishment deed. I release my rights on that X property, and my brother can acquire it as a sole proprietor. So we have to see if this is crafted in a way it is properly curated, then it should be legally valid. And it's just a plain piece of paper without the proper legal framing, then it may create any disputes if somebody wants to challenge that.
Okay.
So there are other tools like power of attorney, gift deed, trust. These all are connected with the will. And since it's the first session, so we kept it simple and then just to brainstorm around the will. But we do help with will, trust creation, power of attorney, gift deeds, everything. Can crypto investment be included in a will since they are banned in India? Yes, they can be included in the will.
How does someone create a will if they are not in India?
So we have our online platform. They just need to fill in the information. We will prepare the will draft and send you via email. So it's completely from comfort of your home. And then you can take the printout of your will document, or we can also arrange it on Indian stamp paper and courier it to your home country. Then you just need to sign it and witness it there.
Okay, thank you.
Thank you.
How about
What are
just a fact?
the
Sorry.
Anu, please go ahead.
what are the documents a person should be having before they start the will writing process?
Correct. So it should be, it's divided in like three sections. Your information as a will writer, your Aadhaar card or your OCI card, your passport. So at least one ID proof, ID number should be mentioned in the will, and then your family's details. It's just the name, their DOB, and their Aadhaar cards if you want to put in, and then the list of your assets. So you should know, and sometimes it's also in your tips that yes, I have this FD, I have this mutual fund. So it's just the listing down of the assets. That's it's pretty simple.
Thank
You
you.
don't need to go to your locker and just keep your property papers and every single documents in your hand. It's just the listing down of your assets.
Got
And it
it.
can be modified once we do a first will draft, and then you can check and go through, skim through. If any missing information is there, we can add on and then modify and finalize it.
That can be done even after that person is like not there anymore, right? Like if
No,
there are anything that's not included in the will, but they have written a will, but it's not included in the will, they have gotten some assets later on.
yeah,
Uh, will it
yeah,
be
that
included
can be
after?
in, yes, yes, that will be part of the residuary. That means remaining assets, which are not part of the current will, but they can be transferred to my residuary beneficiary. So we take care for these legal jargons and provisions while drafting.
Sure. Thank you. Thank you.
But this is the, good question. Like a lot of people ask that, yes, we are in our early stage of, investing, acquiring assets. So yeah, how does it work? So you not need to worry, it will be captured in your bill.
What I was asking earlier, Monica, was what if it's just cash? Can that be willed?
It just cash, so yeah, you can mention in the will, but it will be somewhere, like it could be in your bank locker or it could be in your home almirah. So at least you need to give some instruction to your family members that there's some, X amount, and then it will be kept safely at this, so that they can locate it. Otherwise, how they are going to find it?
Got it. Any other questions? Going once, going twice. Awesome.
So one
Thank you
last
so
thing.
much. Oh, yeah,
Sorry,
Sufyan, go ahead.
sorry, Nikhil. So let's say if someone does not have a will and the way distribution will happen is based on either their religion or the Indian system of like however distribution happens.
Right.
So if the court decides that, and if the beneficiaries, legal heirs, are not okay with it, then it has to go through some kind of a negotiation process, is it?
No, so court will not entertain these emotions. It will be based on the by default. If there is a will, then there can be negotiation that yes, I do not agree with this, I do with this. But if there is no will, then it will be based on the by default legal hierarchy. For example, if father is not under the legal hierarchy, he cannot go and say that I also want some share in my son's property. So that's why you need to write this as per your choice. You need to control your assets, how it will be distributed.
So if father and children have a mutual consent and then they approach the court and say that like we are, I mean like although three are the legal heirs, they have agreed that like they'll include the
Yeah,
father as
if
well.
they are agreed, then there is no need to go to the court. They can just do internally the family agreements. I mean, then the court intervention is not needed now. If there is no dispute, no problem in the family, they are saying that yes, I want to give something to you, then there is no court intervention needed.
But how will the banks release the money and stuff like that? It will release to legal heirs and then like the legal heirs choose to just give it to
Yes,
whoever.
absolutely. Yes.
Yeah, cool.
Because banks will not go deeper into that how the distribution is happening. because bank's liability will to just get the proper documentation. They will ask for KYC, they will ask for succession certificate, the death certificate and all, and they will release and they will be free. They don't want to be included in the disputes.
The tax implications will be there though. If it is going with
Yes. And the
inheritance,
good news is in India there is no like inheritance tax. Even if you are an RI, you inherit some properties which are located in India, there won't be any inheritance tax.
okay.
There could be some capital gain tax if you rent that inherited property, but on inheritance per se there is no tax. In few other countries there's
Yeah.
inheritance tax.
It's massive here in the UK. It's a
Yes,
nightmare.
absolutely.
Cool. Thank you.
Thank you so much, Monica, for taking
Thank
the
you.
time.
Thank you so
And
much.
to
So it was
everyone
a
who,
new topic for all of you, or like any of you have just, ever heard about it and were thinking to discuss on it, or it's just first time?
I mean, like I've been hearing about it for quite a long time. I
Okay,
also know like how important it is. Like I've seen things happening in the family, but
right.
today was the first time when I could actually dedicate some time on a Friday evening here and then like
Nice.
happen to join.
Yeah, that's where we are trying to build an awareness so that, your family, your future generation should not suffer. And ultimately, we should also not suffer. We should focus on whatever is, required for the time, not just running from pillar to post, just to acquire what is already ours.
Yeah, fair enough. Thank you. It was very insightful.
Thank you. Thank you so much for your time here.
thank you everyone for taking the time to join us today. We'll share a copy of the slides and also the recording in an email that goes out in a day or two. And Monica, really appreciate you for taking the time for sharing such an informative presentation. I mean, I'm from India, but I moved to the US like 10 years ago for my bachelor's, and I
Okay.
wasn't aware of many of the things that you shared. And now I understand why certain people in my family behave the way they do. I'm just kidding. Everyone's golden, but incentives drive behavior, right? So it's important for people to take ownership, especially if they worked
Correct.
hard to build businesses, accumulate assets, what have you, and to guide the direction in how that's distributed after the time here, right? So
Correct.
the work you and the team are doing are is incredible, it's so important, and I appreciate you taking time to share with us today.
Thank you. Thank you so much for giving me this opportunity to discuss this important topic. Yeah, I would love to connect if any further queries, like any of the attendees have any queries or your friends or family, anyone in your network, just feel free to reach out to us.
Amazing. Thank you, everyone. Have a
Okay.
great weekend and wishing all of you a very happy holidays. We'll also send out Monica and the team's contact information in the follow up email. And have a wonderful rest of your day.